All right. Good morning, everyone. My name is Brent Burchett. I'm Executive Director of the San Luis Obispo County Farm Bureau. We've got a great group here today. We want to let you know that we are recording this webinar so everyone will be able to watch it afterwards. We're also streaming live on Facebook. I think that's working. My staff, Matthew Graybill, will be behind the scenes helping us out today. I'm going to let each of our panelists introduce themselves in a moment and kind of go through the highlights of our agenda today, but just want to say a big thank you for being with us. We know this is a big issue, not just here in San Luis Obispo County, but across California. And we had this similar topic last December, and had 100+ people from across the state. So we thought it was important to come back to you and give you an update on where we are today here in November of 2021. Our title of today's session is Death Tax on Agriculture Inheritance. What does Prop 19 and Senate Bill 539 mean for California farmers and ranchers? And I know we have a lot of folks that may not be full-time farmers and ranchers, but this information is very applicable to any property owner here in California. Oops. All right, before we get into our agenda, I want to encourage you to join Farm Bureau. I think most everyone here today is a member of Farm Bureau, but your membership is what allows us to advocate for you in Sacramento and across counties. So if you're not a member of Farm Bureau, I would say, why not? Do you not believe in agriculture? Do you not believe that there's a whole lot of regulations and challenging issues that need the voice of farmers and ranchers to speak up for? So you can learn more about our SLO County Farm Bureau at slofarmbureau.org, or you're welcome to contact our office and we can put you in touch with your county farm bureau wherever you are in California. So we're going to start with Assessor Bordonaro, and we are very fortunate to have him in San Luis Obispo County. And today, really, he's kind of wearing two hats. One will be his role in SLO County and kind of explaining some of these details from an assessor's perspective, but also Tom was instrumental in advocating for the changes that we're going to go through today. That was the implementation legislation for Prop 19. And Prop 19, as Tom will allude to, really was worded very poorly, very confusing about what it actually meant. And the Assessors Association, which doesn't really engage in political type advocacy, they looked at this thing and they knew they had a whole host of problems that really required their attention. And we're so thankful to have Tom here in SLO County, but he really had an outsized role across the state in making sure Senate Bill 539 did not impact farmers and ranchers like we really were afraid it would be. Also, we're pleased to have with us Farm Bureau member Victor Herrera, attorney at Carmel Naccasha, and Victor will go through all his legal disclaimers, but this is informational today, Victor, and I'll let you do your disclaimer later, but we wanted to kind of get through a little bit more of the details. So Tom's going to lay out the kind of the overview of what we're looking at, and Victor's going to go through. I ask that you hold all your questions until the end. I think Tom and Victor will go about an hour together, maybe a little less than that. So hold your questions from the end. But as you think of questions, you're welcome to submit those now in the Q&A box. I had several questions submitted earlier, and we'll also be available after the meeting. If you think of something, you're welcome to contact our office. We'll get you in touch with these two gentlemen and try to get an answer to your question. All right, with that, I'm going to turn it over to Tom, and Tom, I'm going to ask you to unmute. You should be able to now, sir.
All right, thank you. I know, sir, I like you on those controls, Brent. You have too much power. So thank you for this opportunity. My name is Tom Bordonaro. I am the county assessor for San Luis Obispo County. I've been so since 2003. Prior to that, I was in the state legislature and the assembly representing San Luis Obispo and Northern Santa Barbara County. And I sat on the agriculture committee for my entire term. And I can tell you that Brent is absolutely right. If you are not a Farm Bureau member, you need to be, and you need to get all your friends, even if they're not in agriculture, because there is an assault on agriculture coming out of Sacramento, which is totally controlled now, pretty much by the Bay Area and Los Angeles with their populations, and with fewer and fewer people in agriculture. The voice of agriculture is weaker. However, Farm Bureau does a great job in advocacy, and they can't do that without your support. But the longest job I've ever held is also being a rancher here in San Luis County. I've owned a piece of ground that we've farmed, our family has farmed. My father and I are partners. He's since passed. But since the days when, probably before Brent was born, when we wore bell bottoms, not on the ranch, always wore jeans, but since the 70s, I've been in agriculture. So I've seen the assault, and I want to thank the Farm Bureau for working together with the Assessor Association in trying to make some sense of Prop 19. Go ahead, Brent. So Prop 19 was put on the ballot originally by the Realtors Association. The goal of Prop 19 was to increase commissionable sales, and that goal has been achieved. You can go to the next slide, I think. And it had three parts, but what it was trying to do, this passed in 2020. 2018, they had the same thing on the ballot. It failed because it had a very large cost to it. But what they're trying to do is allow people to transfer their base year across county lines. Those county lines, only about 7 counties allowed to transfer across county lines. It was a county option. And the realtors wanted to see people have a little more mobility, as seniors nowadays move around a lot. Prior to that is Prop 60 that allowed for a base year transfer, but it only applied if you're 55 or over, and it only applied one time within the county. It could, and like I said, 7 urban counties had it so you could cross county lines. No one knows where the county line is between Orange County and LA County. People move back and forth all the time. But like I said, back in 2018, the price tag was way too big. So that was the first part. The second part was the realtor scheme to pay for it all. And that was to take Prop 58 and Prop 193, which were the parent-child exclusion and the grandparent-grandchild exclusion, and basically throw it under the bus. That actually pays for the property tax loss. The reason there's a property tax loss with the base year transfer is when you cross county lines, your old home is reassessed, and your new home, the value, the assessed value is suppressed. So when you're doing it within the county, it's a net sum zero. But once you cross county lines, it creates winners and losers. San Luis Obispo County is a loser county. We have more people moving in that are affluent than are moving out. So somebody sells their home in San Mateo for a couple $1 million, where the median home price is $1.8 million. They sell it down there. They've had it since the 80s. They have a $200,000 tax base. They bring that lower tax base down here. They buy a home for $1.5 million, and they receive a $200,000 tax bill from the tax collector. And San Mateo gets a reassess up to what the market value is, but not San Luis Obispo. So that's why there's winners and losers. And then the legislature, nowadays when an initiative is put on before the legislature can tweak it, and the proponents, if they agree, will allow that. So Senator Hertzberg carried the constitutional amendment that eventually put Prop 19 on the ballot. It created this fire and local government funds package. So basically the counties that were winners would put money, theoretically are to put money in this fund, and the counties that are losers will be able to draw from this fund, but it's also to support fire. So if you remember fire suppression, if you remember back in the day when this was on the ballot, there was a lot of advertisements showing fires in the background. And if you voted for Prop 19, would be able to fund fire departments. Well, if you talk to folks in CAL FIRE and other counties, nobody knows how this is going to work with this fund. I've been around long enough to know that it probably won't work. It is a sales point and nothing more than that. So I'm going to kind of go through what this did. And the first part is I will say what it did for you. So now, in prior law, you can, if you bought a new home or constructed a new home within 2 years of sale, you can move your tax base over to principal residence only, but it had to be in the same county or with county ordinance, 10 counties had that county ordinance. It was only allowed one time, and if it had to be equal or lesser value. So the theory was, I'm in a 4-bedroom home. My kids have all flown the coop. I don't need this 4-bedroom home anymore. I want to buy a 2-bedroom home, but the market value has gone up that if I if I sell it and buy a new home, I won't be able to afford it. So it was meant for people when they were either buying or equal value, or they were buying down. If you buy the replacement prior to the sale, you got 100% transfer. If you bought it a year after, you got 105. 2 years after, you got 110. That was so people could buy a lot and build a home on it and then still transfer their old tax base. So Prop 19 really opened it up for people over 55, plus those that are disabled, and that's permanently disabled. So it was, let's say you had a 2-story home, you became non-ambulatory, and you needed to buy a 1-story home. If you did that, your taxes would have gone through the roof. So they allow, and you have to go through a certification process if you're disabled. So Prop 19 now says you get the principal residence, the same thing with purchase or new construction within 2 years of sale. So that didn't change, but now you can go anywhere in California, and you can do that 3 times, and you can go any value. So now you can buy up, but if you do buy up, then there is a proration that we have to go through. So if you sold a home that was, market value was $1 million, you buy one that's $1.5 million, you would get your old tax base and then the additional amount over and above what you paid for the new home. So that's basically, that is what Prop 58 did for you. So the next slide, I'm going to tell you what Prop 19, I'm way ahead of myself. This is a summary of base year value transfer. It was effective last April. Eligible owners can go anywhere in California, 55 or over, transfer maybe to a residence of any value. And then it did add wildfire and natural disaster victims, which used to be by county ordinance only. But if there's a governor proclaimed emergency and you wanted to move, you can move your old tax base to a new property anywhere in the state. And that does not have any age restriction. So next slide, please. This is how it works. So your old base value is $300,000. The market value of the original property is now $1.3 million, which is not uncommon here in California. You buy a home for $1.5 million. So you take the 1.5, subtract out the original property market value, and there's 200,000. You would add that $200,000 difference to the old base value, and your new base value is 500,000. Prior to Prop 19, your new base value would have been the 1.5 million. You would not have qualified whatsoever for a base year transfer because you were purchasing a property that the market value was more than the one you sold. Pretty straightforward. So then this is what it did to you. So one did something for you, the other lake did something to you. And that is the parent-child to the grandparent-child, grandparent to grandchild exclusion. So prior to Prop 19, you could transfer your principal residence and all other real property could go to your children, to your heirs. If your children were deceased, it could go to your grandchildren. There was no value limit for the principal residence. So if you had a home in Malibu that you've had since the 70s and it had a $200,000 tax base, now it's worth $6 million. That $200,000 tax base gets transferred over to your children. They have to apply, and then of your other property, whether it be a second home, a vacation rental, a business, any other type of real property that's being held, you could transfer up to $1 million in taxable base. So in this case, let's say it's your farm or your ranch, and you've had it for quite a long time, and the assessed value is under $1 million. Your children would get the benefit of that and could retain that old tax base. And you had 3 years to file. Now what Prop 19 did, which very much narrowed that exclusion, it can only be for the principal residence of the person transferring and of the person receiving. The difference you get between the market value and the base year value plus $1 million, so it's a $1 million exclusion only. There was a provision that a family farm did not need to be a residence. So if your family farm was just open ground, then that would also qualify. But for the home portion, you have to file for a homeowners or disabled vets exemption within a year. File the claim within 3 years. So basically, your children have to move into the principal residence and they have to make it their residence. Now, how is that going to be policed? I don't know. I'm not a cop. I'm not going to go out and check every year. We're still waiting for what is expected for assessors to do to try to track those. Because what happens if somebody moves out? So a child moves in, they file their homeowner's exemption within a year. 5 years later, they move out and move to Texas. How does the assessor know that? And then we have to track the old value. So then we can reassess it up to what it would have been if they never received the exclusion. It's going to be a nightmare no matter how you cut it. Next slide, Brent. So again, summary, this was effective February 16th of last year. So the base year value can be transferred to the principal residence only. And again, like I said, the exclusion is supposed to be removed if a transferee later moves off the property or no longer qualifies for a homeowner's or disabled vets exemption. All other real property does not qualify for a second home. Commercial property, rental properties, real property such as that. And the value limit of the base year plus $1 million that is adjusted biannually, which is a good thing. But you have to apply for that homeowner's or disabled vets exemption within a year of the transfer date. So it severely narrows the exclusion. Now the family farm was left in there and it was not written very well. So it did allow for the family farm to be included, but the way that it was written, it was the entire property. So as you know, those are still eligible for the parent-child, grandparent, grandchild. It was, actually the slide's incorrect. It should not say separate exclusion available for each legal parcel. So I'm sorry about that, need to fix that. But you don't have to have a principal residence on there. If you do have a principal residence, you could qualify for two, one for the residence, one for the farmland. Go ahead to the next slide. So again, how it works. So the current base year value of the home is 300, market value is 1.5. You take that difference and you add them together and your new taxable value is $500,000. So you got a $1 million exclusion. Go ahead, Brent. So now the problem was, again, it was written very poorly. It was written in the dead of the night. It was jammed down people's throats in the legislature. We lobbied hard to get it changed before it went to the ballot, but it didn't happen. So there was an ad hoc committee formed, which I and my staff headed up statewide with the Assessors Association, and we parsed through the entire Prop 19 and line by line came up with what the problems were and suggested recommendations, which then went into a bill called Senate Bill 539. Go ahead, Brent. There you go. So this is just the first page of about 20 pages of problems that existed under Prop 19. I'm not going to go, well, maybe I will go through each line line by line, but I think that might put you all to sleep. A lot of minutia, a lot of problems. So like, for instance, if you look at the bottom of the first page, Prop 19 said a person has to be severely disabled. The law before said severely and permanently disabled. So is there a difference? Would this include mental disability as well as physical disability? I mean, it just opens up a whole can of worms. But I'm not going to go into that detail. So go ahead, Brent, next. Oh, there's another page. We'll skip those. Another one, skip that one. So now, we were able to take and parse through and put into 539 as much as we could. Senator Hertzberg was very willing to work with us. It was difficult to get his attention. But once we did, it opened up for every other special interest group to try to get a piece of the fix. I've spent quite a bit of time on the phone with them. I served with them when I was in the legislature, which is great because I was able to talk to them personally and explain to them that at the time when Prop 19 was being advocated for and when it was put onto the ballot, family farms were promised that they would be held harmless. And unfortunately, the writing didn't do that, but we tried to fix it as much as we could. So here are some of the, instead of going line by line, here are some of the fixes that we were able to get. Because there were some things that were definitely glaring issues in Prop 19 if you just pull back and don't dive into the weeds. But one of them was, again, people could buy a lot and build a home. Well, if you bought a lot, you buy a lot and build a home in California, you're going to go over that 100%. So they defined equal as allowing the 105% in the first year, 110% in the second year, and you still get the full tax base benefit. It also included accessory dwelling units and junior accessory dwelling units, which are kind of a new thing. An ADU is, you built a little second house on your property and use it as a rental. We usually call them mother-in-law units, something like that. A JADU is if you take a piece of your house, let's say you're able to wall off a section and make it an apartments, you're not changing your footprint, but you're doing on the inside, putting in maybe a little kitchen, maybe a little studio apartment or whatever it is. Then we made sure that it included those also. And we made sure, because some of the wording actually canceled out some of the disaster provisions that were already in place, which didn't make a lot of sense because of, and again, I'm not going to go into too many details, but we wanted to make sure that people that were victim of natural disasters could benefit from a base year transfer. So we made sure that that stayed in place, that there wasn't a conflict. For primary residence, if somebody moved out, it allows another transferee to move in within a year. So let's say there's, you have 3 children, you leave the house to all 3, one of them moves in, and then that person, for whatever reason, has to move. Then one of the other siblings can move in and still get the exclusion. So that was one of, I think, a major cleanup. But to me, the biggest thing that we did was we took the family farm and we defined a farm as a legal parcel. That way you can receive multiple $1 million exclusions. We kind of did it in the quiet of the night. Well, we made the amendment and then kind of kept quiet about it. That is a major change in the bill, a major change in Prop 19 that many advocates, I honestly believe that if some special interest groups had found that out, they would have tried to kill it. So we kind of slipped it in there and then let it slide. And we won. So we held Hertzberg to his promise and he didn't disappoint. So again, some of the big things that we talked about is that previously you had to pick between your favorite child to go into the house. So we solved that. It did limit it for the entire family ranch or farm. So we would have had to assess the entire property. You could have 1 parcel or 200 parcels. Didn't matter. It was 1 unit. That was the big problem with Prop 19 and putting $1 million exclusion on it, especially properties that are anywhere near the coastal range, or what values have done statewide. It would have destroyed the family farm. There's no way farms could have been passed on to their children without huge increases in their property tax. That was the biggest problem with Prop 19. So the only thing we could come up with was make it each legal parcel. So if you have 200 parcels, you could be eligible for 200 separate exclusions. And it also clarified that the family home and the family farm are both eligible for the exclusion. So if you have 1 parcel, you have a 40-acre strawberry farm with your principal residence on it, you would actually then qualify for two $1 million exclusions, one for the home if your child moves in it, and one for the property if you leave it to your child. I think a huge victory for Farm Bureau and for family farms statewide. Next slide. So now Howard Jarvis comes back and says, you know, this whole thing about throwing the parent-child exclusion under the bus, unacceptable. So now they're going to, they're initiating the repeal of the death tax. So it will restore Proposition 58. I mean, look, in California, the only way you're gonna be able to pass on properties to your children and be able to afford those taxes is if that Prop 58 is restored. Helps build generational wealth. And, you know, minority groups, especially in certain areas, are realizing that they've had their home for quite some time. Property values have gone crazy, and they're not going to be able to pass them on to their children and be able to afford those property taxes. So they introduced it. It reinstates both 58 and 193. 193 was the grandparent to grandchild exclusion. It does increase the base of all other properties from from 1 million to 2.5, and then it does index that. So that would be where farms, ranches, rental properties, vacation properties would fall under that base exclusion. They've got to get a 1.5 million signatures by April 30th. But the important part, and I'll go into that in detail, is that SB 539 will be retained. Now it is in their R&T code by the legislature, so it could be repealed, but it does not, this new initiative by Howard Jarvis will not negate the good work that we did under SB 539. Next slide. So I have a couple scenarios to show you. You know, we're going to fight to make sure both of them stay, that 539 stays in law, and that the repeal of the death tax also passes. So here's an example. Under 539, parents transfer the children. They have 4 cultivated parcels. Each parcel's worth $600,000. So we're just doing this to make it easy. That never works out, right? You never have 4 parcels that are exact same size. Current market value is 1.7. So under SB 539, you take the assessed value, right? And you take the $1 million exclusion. So you get a $1.6 million exclusion on each parcel, when prior to 539, it would have been on the ranch in its entirety. So the result is that the market value of each parcel, right, will exceed 539 by 100,000. So you got 4 of those. So it's going to be, you know, each one's going to go up about $4,000 a year. And you might say, well, that's a lot. Well, it is. Without 539, it would have been over 30,000, because we would have had to look at the entire ranch, all 4 parcels as one unit, and then apply the $1 million to one unit. If the death tax initiative passes, then there will be no tax increase, because the $2.4 million covers, plus home of any value, will be covered by the 4 parcels. And we just happen to do this scenario because 4 times 6 is 2.4 million. But that shows you that huge benefits under 539, and and even better benefits under the repeal of the death tax. I think I have another example. Go forward. Here is an example of a situation where both of them had no reassessment. So if the assessed value of those parcels were 700,000, right, then there would have been no reassessment under either scenario. And you could think of other scenarios where the death tax, where actually 539 would be more beneficial than the repeal of the death tax. So I think it's really important, and I will advocate that again, that 539 not be changed, and which they won't. I mean, look, once an exclusion is granted, it's very hard to go back and undo it. So playing defense is a hell of a lot easier than playing offense in the legislature. And if we get the repeal of the death tax onto the ballot, and it will pass. When you talk about death taxes, it cuts across party lines. Right now, the focus groups, the yes on repealing that death tax for property value polls at over 70% yes. So that is going to be a very hard one to stop if they can get the signatures. Next slide, Brent. Now, I just want to talk a little bit about the fact that both of them, 539 and if the repeal of the death tax were to pass. There was a court case not too long ago in the early 2000s called Strong versus Board of Education, where the legislature granted an exemption, an exclusion, and an assessor from one of the counties that did not agree with it filed a lawsuit and said, you can't do that because it's not allowed in the Constitution. But the court ruled correctly that the legislature has the power to create exemptions from property tax increases unless they are prohibited by the state constitution. And the big difference, and people should understand, the big difference between the United States Constitution, which is a group of states that got together, they granted power and created this beast called the federal government. That is a grant of power. The California Constitution is usually done through an initiative, although it could be through the legislature, and it is to limit power of the state government. So unless it is prohibited by the state constitution, then the legislature can pass a law and change it. And I'll give you an example. Under Prop 13, which you know is what all of our property taxes are based on, is in the Constitution. It limits the powers of what a reassessment is. But it also says that, we can only reassess, assessors only reassess when there's a change of ownership or when there's new construction as defined. So it leaves what is a change of ownership and what is new construction up to the definition of the legislature. And so there are other propositions. There's been, we're off the top of my head, there's over a dozen other ones that have been put into place that further limit what can be done with reassessment. But so unless it is explicitly prohibited, then the legislature has the power to do that. And I say that only to say that SB 539 does not conflict with this initiative by Howard Jarvis to repeal the death tax. And I think I've endorsed it. I am getting very heavily involved with it because I think it is fundamentally unfair that it is only your primary residence up to $1 million. With the way that this real estate market is going, especially, if you live in San Luis County, you know how crazy it is. It's absolutely ludicrous. My kids are never going to be able to afford to buy a home here the way that it's going. And with Prop 19, people are moving in and they're more affluent and they're driving the prices of homes up. They'll pay anything right now to get a home in San Luis County. It's fundamentally unfair if you own a small business that you can't pass that business on to your kids without a huge increase in property tax. So I'm going to be signing on. I encourage all of you to take a look at it. You can just go to the Howard Jarvis, Google the Howard Jarvis Taxpayers Association, read it for yourself. If you have any questions, you can email me or email them, and we'll see if we can get it on the ballot. So there you go. That's my presentation. There's my contact information. You can always email me. You can go to my website. There's a lot of FAQs on my website, but the best way is either email me or just make a phone call. We'll answer any questions that you might have because I know if you're like me, you'll go through this presentation and then at 2 a.m. you'll think of the question. So just email me anytime. Thanks, Brent.
Tom, that was incredibly good and helpful. I know that's a lot for everyone to digest, and Tom mentioned this. We'll make sure to share all the slides. I know that came up in the questions someone asked us. We will make Tom and Victor's slides available to you all as part of this presentation. You'll get an email with both those documents. We'll also post them on our Facebook page and our SLOfarmbureau.org website. All right. We're moving right along. We're about right on time. Tom, you were perfect at 30 minutes. So Victor, you should be able to bring up your slide, sir, and I will turn the floor over to you. I want to say a big thank you to Carmel Naccasha for letting us use Victor's valuable time today, and I'll let him give the background on his law practice, but we just appreciate our partnership with Carmel Naccasha, and thank you so much. Look forward to hearing from you, Victor.
Well, thank you very much. I hope everyone here can see my screen. Brett, if you can nod your head, can you guys see my screen? Okay, fantastic. And thank you, Mr. Bordonaro. That was fantastic hearing from you. My name is Victor Herrera. I'm an attorney at Carmel Naccasha. I'm actually new to the area. I moved here about 6 months ago. And I have to say I'm enjoying the San Luis Obispo life. It's quite a big difference compared to Riverside County, which is where I was living before. As Brett had earlier made a comment about, this is not, please don't treat this as actual legal advice for your specific situation. If you have questions or comments or concerns or want advice about your specific situation, reach out to your own attorney or reach out to us because every case is going to be different. I can only really talk in big, broad strokes right now to kind of let you know how I look at this from an attorney's point of view. And I happen to agree with a lot of what Ms. Bordonaro was saying, but I'm not necessarily as prosaic. Because I'm a lawyer, I always think people are going to sue, and there's going to be a lot of I can guarantee there's going to be a lot of litigation about both Prop 19 and Prop 530, Senate Bill 539 for either definitions, constitutionality, or a whole host of reasons. And so this is going to take a long time for us to really iron out the details and see how does this actually get implemented both on a local level, but also on a statewide level, because I can see every assessor reading some of this slightly differently, implementing different forms behind it. And then also just as things develop and lawsuits come down the pipeline and the courts make decisions, it can have an impact on how all of this is implemented just across the board. So to a certain extent, we're doing a little bit of fortune telling today and doing quite a bit of guesswork. But I think there's a strong foundation to this guesswork. I mean, this isn't like the first time there's ever been a change to a tax law. So we can kind of look back in the past and see what we've done in the past and how people have read it to get an idea of what's going on. So really quickly, Carmel Naccasha, a local firm. We've been around for almost 2 decades now. I have a slide up right now with the founding partners, Timothy Carmel and Ziad Naccasha. Since I've moved here, I found out these two are known everywhere. It's kind of distressing that everywhere I go, one of these two men are known. And I'm always worried that something's going to get back to them about something stupid I did. But hopefully I'm minimizing my stupid mistakes since I'm new to the area. Like I said, I just moved here. Like I said, I'm really enjoying it up here. My focus is largely on estate planning. So wills, trusts, conservatorships, guardianships, and obviously a lot of that includes the transfer of real property, which is really what we're talking about today. And then the firm itself is also very active with the county and the communities out here. I honestly don't know how long we've been active with the Farm Bureau, but I know Joe Benson gave a presentation last year on this issue right after it got passed. And I hate to say this, but we don't have that much more confidence today than we did a year ago on everything that's going to happen going forward. Like I said, 539 is a great step forward, but I think Mr. Bordonaro would also agree that there still needs to be a lot more done to iron out what his office is supposed to do and how they're supposed to do their job. Because now that it's in law and it's a law that's been passed, he's got to implement it. And as he pointed out, and he skipped, I saw some of those highlights and I was reading some of those little comments he had. And what's funny about it is his comments are similar to mine, but still different. And I'm sure if we sat down over an hour, we could probably find 30 different reasons each of us would disagree with some of the language that's in the statute and everything else. And so it's going to be a nightmare for him to implement. And I'm sure he's going to do his best to do it right, but I'm pretty sure he's going to get sued or someone's going to get sued about this. So really briefly, the prior tax scheme was largely developed by Prop 13. That was passed in 1978. And there's been a bunch of props and changes in the intervening 40 years that kind of clarified and strengthened what was going to happen to people and their properties as time went on. But there really wasn't a large change. Like I said, it was mostly clarifications and slight amendments to the underlying Prop 13. And really with Prop 13, it was just when would your property taxes change upon a transfer of property? It didn't do anything with capital gains. It didn't do anything with estate taxes on the federal level. It didn't do anything for insurance. It didn't do anything. It just dealt with property taxes, which granted, given the cost of property nowadays, that can be a lot of money, especially over years or decades. So it's not something to obviously sneeze about, but it only dealt with that. Now, the applicability of Prop 13 was designed to lock in tax rates for homeowners and other property, so it included investment property. And then, like I said, it was modified over the decades to include transfers to children or to grandchildren in certain scenarios. And then, like I said, it applied to your primary residence, but then also it included industrial properties, investment properties. It was much more expansive, which was great. And then, like I said, it can only go to certain family members, so children, grandchildren, but it could also be adopted children and stepchildren in certain limited circumstances. And that's what we had before. So this is going prospective. It's everything that's happened since the Prop 19 was passed last year. And I apologize. Some of the stuff I'm talking about right now is a repeat of what you just heard, so I apologize with that. But it's still important to know because it's going to have an impact on everything else that we discuss. Prop 19, it only applied to your principal residence. And probably one of the biggest complaints for people was it had to be the primary residence that you lived in. And then whoever was taking over the property, it had to be their primary residence, and they had to move in within 1 year. So what happens if they move out after a short period of time? How, there were questions about, like, what if you had multiple children? Did they all have to live in that property? If it was multiple grandchildren? None of that was really written into the language, which goes directly to like that whole kind of confusion and questions that Mr. Bordonaro was talking about. Now, what it does is it says there's no change to your tax base if after the transfer, which is specifically defined within the code itself. And I'm not going to go into that detail unless someone wants to later. But there wouldn't be any change if it was the market value was equal to or less than the current taxable value plus $1 million. And so if it was less than that, you would keep your prior tax basis. It wouldn't go up. And then if there was a difference that was, original tax basis plus $1 million, you would still have the original tax basis, but then you would have to get an additional tax basis on the difference between the two. So obviously some of the ambiguities with Prop 19 was if there are multiple children, how long do you have to be in the residence and what constitutes leaving? If you're in it for 8 months out of a year and you rent it the other 4 months, did that mean you abandon it? Obviously, it was very easy if you just flat out left the state and said, I'm not coming back. That's a real easy example, but how often do you have that scenario? Then there's a whole set of questions about what if you want to live on the property, but were unable to do so, like assume it was condemned, you're in custody, there's a legal dispute over ownership, or right now with the pandemic, like if you go on vacation and then you're not allowed to leave the country, say you go to Spain for vacation, they have a new outbreak and you can't come back to the United States. Well, are you abandoning the property in that scenario? You want to come back, but you can't. So I think those are going to be some of the things that down the road are going to be litigated regarding Prop 19. And obviously for most of us, these aren't scenarios that are really going to pop up, but they could. And so we're just going to have to keep our eye out for it. Especially, like I said, if you wanted to occupy the property but are being prohibited for some reason, that's going to be very specific. And I think the intent with Prop 19 was any child. It didn't have to be all the children were in the property, but it didn't say it specifically, and so it raises the question. Now, with with Senate Bill 539, it did address some of these ambiguities, which is great, and we're probably going to need more Senate bills or House bills down the road to once again clarify other things that pop up as this gets played out. And then key thing is it's retroactive to February 16th of 2021. So anything that happened between February of this year and September of this year regarding these properties, it goes back to February. So if someone messed up along the lines, or there were questions that were ruled against you, well, with Prop 539, if it's in your favor, it goes backwards and you get the benefit. If that happened to you, I would strongly reach out to your local assessor's office and try to work with them with it. Now, what's the way to implement this popped up in internal revenue, or sorry, the Revenue and Taxation Code 63.2. It's a fun read if anyone was interested in reading it. But yeah, it's something else. Why is my not going down here? Okay. So I'm only going to highlight a couple of the sections of 63.2 before moving on to some samples and scenarios. But this is the key language here that really helps with the farms. Okay. So 63.2A2 is regarding the purchase or transfer of family farm is between a parent and children. Okay, then it goes on to this exclusion shall apply separately to the transfer of each legal parcel. And that's the huge thing here is if you have a multiple parcel ranch or farm, you get this exclusion for every single piece of property. So, you know, in the aggregate, you could be well over market value, you could be well over you know, your tax basis, but then if you have 30 pieces of property, or sorry, 30 parcels, you get in essence a $30 million bump, if you will. Like that's how they start doing the calculations there. So it can really help you. Where it can hurt you is if for some reason you just have one extremely large lot, then that's the one you're stuck with. There's also going to be questions down the road about you know, how do you value that property and who's the one, you know, and that can be, I'm sure, where most of the fights are going to be is when the assessor's office says it's worth X amount of dollars and you're going to dispute it saying it's worth significantly less. I think that's where a lot of the fights are going to end up being about when it comes to property transfers. Then the other one that was brought up earlier was like, if you're home, so you get one, so let's go back to the scenario where you have just one large lot. Well, you can get an exclusion just for your home and some of the reasonable land around it. And then you get another exclusion for the rest of the land that's on the parcel. So in essence, you get 2 for 1 in that type of scenario, which once again can be really useful. But I think there's going to be litigation regarding what constitutes the reasonable land around that home. Is it, you know, just 50 feet? Is it 500 feet? Is it to the fence? Given how much people like to argue about stuff, and given that this obviously will have a huge impact for tax bases, I'm pretty sure that's going to end up with a lot of litigation and disputes as to what does it actually mean. Yeah, so once again, on A2C, that's the family home plus the separate property. And then 63.D, that's really where it talks about how do they calculate the various property values. And since you guys are going to get this slide, I'm not just going to read this to you. You can read yourself. You'll get a copy of it if you really want to read these sections. It's section 110.1. That's going all the way back to the 1975. So I'm not going to bore you with that, but I'll let you have this. So if you want to read it at your own leisure, you can. And this is really where it breaks down. The way you look at it is you go, what was the tax basis? So what was it when you purchased the property? All right, so if you purchased the property in 88, that's the basis you look off. Then you add $1 million. Then what you do is you look at the fair market value. If the fair market value of the property is less than, is less than what you purchased it for in the 80s plus $1 million, you keep the original tax basis. So whatever you purchased it for in say the 80s. If it's property value that you purchased, the tax basis from the 80s plus $1 million, if the fair market value is more than that, you keep your original basis and then you have to pay taxes on the difference. Okay. And that's where it can get really tricky because obviously, like you said, property taxes are constantly climbing. And I think the key thing on a lot of this is the date of transfer. So that when it comes to parent to child or grandparent to grandchild, that is the date of death. It's not necessarily the date that the probate finishes or the date that you signed the trust transfer deed. It's actually from the date of death. Okay. And the other key thing about this is all of this is only applies to anything that happens after February 16th of 2021. So if someone died prior to February 16th of 2021, you go off the old numbers. You still go off of Prop 13, not Prop 19. Even if the paperwork isn't completed until sometime this year or next year. So it's key to the date of death is really what's key, and that's what's going to control a lot of things. Now, what are some potential issues with 539? I think on a local level, there's going to be questions about how do you determine the value of the individual parcel, and how much of the fight is that going to occur. And that's largely going to be dealing with your local assessor's office. And maybe Tom can jump in on this later. But that's really going to be a big question between you and the assessor's office on how do you value it. Because obviously certain land has different value depending on what it's used for. Are you usually used for fallow land? Is it going to be agricultural? Do you have other uses for it? Is it landlocked? I mean, there's just a whole host of factors that are going to go into determining what is the value of it. And that's really just going to be a question for your local assessor's office to figure out that one. An example like the one, does the child that live on each parcel of land? So the exclusion, and now I think I'm being a little sarcastic here, but it's just something I could see someone arguing about, is the new language under Senate Bill 539 says each parcel of farmland is going to be treated as a separate farm share. Well, does the child have to live on that parcel? I can see someone arguing that. I don't think that was the intent. And I think anyone that says, someone might argue that you're gonna have to build, a small little piece of property on there so you can go live in it once a weekend or whatever it might be. Like I said, I think I'm being a little facetious here and sarcastic, but I could see someone making that argument that if you have, 60 acres or 60 parcels of land, you're going to have to go build 60 small little homes to go, crash on. And then if you do that, then you get the benefit of the exemption. Like I said, I don't think that was the intent. Nothing that I read, so that was anyone's intent. But because people like to just, nitpick at stuff, and, that's partly my profession's fault. I think that's something that might pop up. The other one is, what happens if the county divides the properties for you, right? If they go through and they're just going through the whole county and they're going, you know what, we're dividing this parcel. We know it was originally 427 acres. We're dividing it up into 6 for whatever reason that they're doing it. Well, in that scenario, do you only count as the 1 that you had originally, or are you now going to get the benefit of 6? And are they going to treat it differently if the county does it versus if you try to initiate that process? And I don't know. That's just going to be a question that I think is just going to take time to parse out. Then, like I mentioned earlier, like how much land around your primary residence is going to be considered part of that one lot. Remember, because if you have a primary residence and then you have a larger land around it, you get one exemption for the home, and then you get another one for the larger piece of property. So I think there's going to be a lot of debate and a lot of work on the assessor's office to figure out where do we draw those lines, because if that can make a huge difference once again, depending on where the house is located versus the rest of the land for accessibility, water, ease of access. All of that stuff is can have a huge impact on the value of the home. As to potential litigation, without a doubt, Prop 19 and 539 are going to be litigated. There's, like I said, it's going to take probably decades for this to all pan out. And I think there's going to be different types. There's going to be some that are going to be litigating just the flat validity of Prop 19 or Senate Bill 539. But then there's going to be some that are trying to get clarification on the points within Prop 19 and Prop 539. I think Prop 19 will likely survive any serious challenges, because largely speaking, the states have a lot of discretion on how they do their taxing. And that's been probably a foundational bedrock to most legal precedent for centuries. And I think with 539, I think you're going to see 2 types of claims. One is the lawsuits for clarification of terms. And the other one I can see is people saying that it treats homeowners unfairly. You're getting unequal treatment. And the reason being is for farms, they get multiple parcels as part of a larger farm. Well, it doesn't apply to homeowners that maybe bought their neighbor's plot, right? So if you have a larger plot and then you buy plots next to it, but then you get it all, you only get the benefit for your primary residence, you're not going to get that benefit for your next, the lot next door that you bought or the lot behind you. And so there can be an argument that you're treating homeowners differently than farm owners, and therefore it's unequal treatment. And I think you're going to see lawsuits on that line. How the courts interpret that, or if the legislator makes changes to that by a new bill, I don't know. But I think it will be something interesting to see down the road. Now, I've got a couple of examples here. So the first one, mom and dad own a single parcel of land with 400 acres, and these numbers are just made up. I know they're not indicative of actual property taxes or values. But let's say they purchased one parcel of 400 acres and was purchased in 1982, and the property taxes are about $10,000 a year. Mom and dad both pass away prior to February 16th of this year. Then all we do is you look at Prop 13. There's no further analysis. We just do what's in the past. Same basic, like I said, my math's all wrong, but just for the purposes of illustration, just go with this. Okay, it's not that funny, Brent. Same basic scenario. Dad passes away in 2010. Mom passes away in March of this year. Well, then we have to look at Prop 19 and Senate Bill 539. So if the current market value is 1.5 million, then we have to look at the taxable value, which is 650, which is what they got it for back in 1982. We add $1 million, so we get 1.65 million. Well, that's more than the fair market value. So then you end up keeping the original 650,000 tax value. Now, same basic scenario here, but now the tax value, or the current fair market value, is 2 million. Well, you're going to get the taxable value of 650, which is what they had in 1982, plus 350,000 more. And that's because the 650, which is the taxable value from 82, plus $1 million, and then you subtract that from the 2 million, and then you get the difference of 350,000. So then you get to pay the taxes on that additional 350. Then this is really where Senate Bill 539 really starts to show its value. So in this scenario, you have same amount of land, but it's two parcels, okay? And they're worth the same amount with the same taxes and everything else. Mom and dad passed away, recently. Well, the current market value for each parcel is $1 million. Well, when you have the 325 in this scenario, that was what it was worth in 1982. You add $1 million, so it comes out to 1.325 million. Well, that's under the fair market value, so you only have to pay the taxable value on 650, or the 325. So not a whole lot changes there. But then, if the property is worth more than the fair market value is worth more than the taxable plus the million, now you're starting to see where you're really saving some money, okay, on the taxes over a longer period of time. Because that's going to be the base value from 1982, but then only 150,000, because that's going to be, as I scenario here, each fair market value is now 1.5 million. So you deduct the 325 and you deduct the 1 million. So you're only paying the taxes on the 150,000. So you can see if you have multiple pieces of property, this can really start to add up. For each parcel, you're starting to get this benefit. And then obviously, if you can get each parcel plus the taxable base is less than the fair market value, you're keeping the original one. So this is a really useful and powerful tool for farmers and ranchers. And it really helps because, if you have a massive piece of land, all right, and it's only one parcel, or even multiple parcels under the prior Prop 19 before Senate bill, your tax bill could be just insane. It could really, I'm sure all of you have horror stories or heard stories of family and friend where they've had to sell land off to satisfy the tax bill, or they have to get rid of it just because they know they're not going to be able to pay the taxes on it. And so you're ending up breaking up a family farm. Well, this, I think, will definitely won't stop it, because there's just too many variables that happen. But this really puts a nice brake check on that kind of scenario, just because you get family farms and ranchers, they get so much more value on this property. They don't have to pay those taxes, which can really break you. And so this is where we're going in the future. Like I said, I can see a lot of litigation is going to go forward on this and try to clarify the issues. But I think it'll survive, which is good. And once again, this is retroactive, so that's really important to anyone that had family pass away within the last, what are we looking at, 9 months now, and obviously going forward. So if you guys have any questions, obviously fire away.
Great, Victor. If you wouldn't mind unsharing your screen, we'll bring it back to the full group. I'm gonna put all right. See if we can go back to everybody. All right. We've got some questions. You all start typing your questions in the Q&A box. If you look at the bottom of your screen and you're on Zoom, you should see a Q&A button. You'll be able to type in your questions. I had 2 questions previously submitted. I'm going to start with those. I need to unpin my video here. Move spotlight. Here we go. Okay, so whoever's speaking will be able to be spotlighted. These questions, whoever wants to take them, we're right on track for time, so don't feel like you need to cut it short. All right, first question. Would it be possible to transfer the farm up to the $1 million allowed to my daughter now and leave the rest in my name? Since I hope to live another 30 years, I was thinking it could save the reevaluation of the whole property at my time of death for property tax purposes. This was
So
previously submitted.
they want to do that. Well, let me think about that. I think that you could, first of all, if anybody has scenarios that are outside of the norm, call us first or talk to your attorney, because I've been in this office for a long time and I am never cease to be amazed on what people do with their largest asset that most of them have. For instance, oh, I'm in trouble with the IRS, so I'm going to transfer my house to my brother until I get out of that mess. Then he's going to transfer it back. And then they find out they get reassessed both ways, right? So don't ever do anything without consulting. We don't give the legal advice, but we can tell you what would happen if you did something. Lawyers are out there to give you legal advice. But yes, you can partially transfer a property, and then that child can apply for that an exclusion. So, we'd have to go through some calculations, because I don't know if it's 5, 10%, 20%, 50%, whatever it might be. But yeah, you can transfer a portion of the property, and that property would be eligible for exclusion that you have to apply for. But we can't tell you ahead of time what's going to happen, because people all the time call the office and go, well, I'm going to do A, B, and C. And so I say, okay, well, if you do A, B, and C, this is what's going to happen. And then they do A, B, and G. And then they're upset because what I told them wasn't what happened, even though they tweaked a little bit.
And if I can jump in on there.
Yes, please.
So, as I'm sure many of you are aware, you have a lot of different competing numbers and interest here. So assuming that's the scenario you go with, you might be able to lower your tax basis for property taxes, but by giving your child an interest in the property, you might end up with issues with step up in basis, okay? Because now your child has an interest in the property, and so you're going to get issues with that. The other concern is not because children ever intend to do it, but let's assume, because I've had this conversation multiple times with clients over the years, you give some of the property to your child, they're on title, child gets in a car accident or child gets sued, child then goes, I don't have any assets, I'm sorry, you can't touch me. And they go, well, you're on title with your mom and dad's house. Well, they can now go after mom and dad's house. Now, that scenario is probably not very common, but it is something that could happen. So you might end up saving tax money, But then your son gets charged with vehicular homicide and has to pay a $2 million judgment, and they go take your home to satisfy it. And, you know, obviously I don't think that's a fair trade. That's probably not what you intended. It was definitely not the intent of your child to do it. But from a legal point of view, once your child's on title, they're considered an owner. So now they're just as liable for taxes, insurance, anyone gets hurt on the property. So it's not as simple as that. And every scenario every person's going to be different, and it might be worth that risk. You just need to really sit down, talk with an attorney, talk with a CPA, work with whoever you can to just really know what you're doing before you do it. Because it might be the best thing for you, but it might end up, you know, biting you down the road.
Tom, you had something you wanted to add?
Well, not on this question, but a couple things that were brought up during the presentation from Victor is that, you know, we racked our brains on 539 or Prop 19 on how we might be able to actually help the family farm. So we came up with this legal parcel definition or legal parcel item, but legal parcel is not defined. And Victor touched on that briefly. The Board of Equalization or cleanup to the cleanup is going to have to come through to define what is a legal parcel. So the people that are watching this, don't assume that if you have separate parcel numbers, you have separate legal parcels, because an assessor's parcel number is just that. That is the assessor's parcel number. It is not a legal document. It does not mean that there is a separate a parcel that could be sold. A legal parcel, I mean, I look at it as, can you sell that parcel out from the rest of them? And so that goes to zoning, that goes to all kinds of different things. And each county defines what their legal parcel is. So I think we're gonna have to either have the BOE, the Board of Equalization, come through with a rulemaking process. Because you gotta remember, assessors used to draw all of their maps in books. That's why when you look at your parcel number, it's a book number and a page number, and then an actual lot number, right? So, or an actual parcel number. So if your land was bigger than the page on the book, we gave it 2 parcel numbers, right? So it's only because it couldn't fit on one page that you might have several parcel numbers. We don't necessarily value it separately. And that goes to one of the things that Mr. Herrera said, is that what we would do is, if you have a ranch that is one contiguous ranch that has 27 parcels on it, just like we do now under Williamson Act, or just like we do on anything else, we're required by the state board to value it as in its entirety. And then we have to allocate to each parcel the value of that. So we don't look at each legal parcel as it's as a standalone property. We look at the ranch in its entirety, and then we allocate value to each parcel. And that is, again, that's an assessor's parcel, not a legal parcel. So yeah, there's going to be a lot of questions. There's going to be, you know, right now my ad hoc committee is looking through Prop 19, comparing it to 539, and then also to put together a cleanup for the cleanup. And like Victor said, there's going to be probably cleanup to the cleanup to the cleanup. This is going to be looked at for many, many years to come. And I'm just glad that the CAA is involved, because we all, now each assessor can kind of do what they want, but not really, because you have the Board of Equalization that oversees what we do. And part of that is to equalize, and we're all in, for instance, everything in 539, all 58 assessors agreed to. So we will be doing our damnedest to try to do it all the same, so that if you have properties in 2 different counties, they're going to be treated the same. It doesn't always work, but that is one of our goals. And, you know, again, the one issue about carving out, if you have a family home, carving out the property that would apply to the family home, and then applying a second exclusion. We do that all the time. We do that under Williamson Act, because, as you know, under the Williamson Act, only the land is protected, not the residents and not the buildings. So we're always carving out farmsteads and homesteads out of So, and we kind of know, I mean, we've got procedures, we've got, court cases and everything. So not too worried about that. We're used to doing that every day in our valuation process. And I just also want everyone to remember that we do have an appeals board. The courts cannot litigate value. They can only litigate questions of the law, and you've got to go through the appeals board first, which is a very good thing because most of the time in our county, at least, I can't speak for other counties, if there is an issue that we missed or information that we don't have, and you come to us and ask for a review, we'll fix it prior to going to appeal, which is probably one of the reasons why I'll get a cheap plug in here, why we have one of the lowest appeals rates in the state of California in San Luis Obispo County. We're in a mass appraisal business, and sometimes we miss information. So bring it to us, and hopefully, we can help you out, but not all the time. And then you would have to go to the appeals board and then go to court, but that cannot be on values of opinion. It can only be on issues of the law.
Okay.
So anyway.
Nope, good info. I'm going to go to some of our Q&As. If you have a question, go ahead and type it in the question and answer box at the bottom of your screen. I'll take these as they came in. Tammy Ventura asked one that sounds easy. What is the legal definition of a family farm?
That was the entire problem with Prop 19. There is no legal definition of a family farm. And that may be an issue that is, my opinion is if it's family owned, could be with partners that are related. It could be the majority partner is related, could be an LLC that is controlled by a family. I could tell you that there are some farms that are obviously not family farms. Large Central Valley farms are not family farms. There are some that are, and that is going to be one of the sources of consternation for assessors. Believe me, we don't like Prop 19. I fought my damnedest to defeat it. We defeated it in this county. It barely passed statewide. Assessors don't like it because of not only the additional administrative burden, because it is going to cause, as Victor said, it's going to wreak havoc on issues such as that. What is a family farm? Everybody probably has a different definition of that. So that is going to be something that will still have to be worked out. I know personally what I would call a family farm, but legally, courts may have to decide that.
And if I may.
Go ahead, sir.
So there is an actual definition of family farm in 63.2 of the Revenue and Tax Code. And it's, even that one's still somewhat vague, but it's any real property under cultivation which is being used for pasture or grazing, or that is used to produce any agricultural commodity as that term is defined in section 51.201 of the Government Code, as that section read on January 1st of 2020. Well, once again, January 1st of 2020. So any future changes to the definition of agricultural commodity, you may or may not fall in and out of family farm. But once again, a lot of this is going to come down to just either litigation and the courts interpreting it, or further statutes that help define it. But I think his point is still on it. It's like there are some that are very easy to know it's a farm. And then you're going to have the ones that are definitely going to be, on the side, that those are going to be a little bit more tricky. But if you're raising cattle, you're growing soy, or what, you're going to be fine. I don't think anyone's going to dispute that that's a farm.
Yeah, most of them will be very obvious. But if you're growing worms for resale at Lake Nacimiento on 2 acres, is that a farm?
That's vermiculture, Tom.
But I mean, it goes to profit. I mean, basically, what most assessors look at is, did you file income taxes on a ag product? If you are, then you're a farm. Again, we don't like to be the police. We're not judges and adjudicators. So, but Victor's right. 99%, 99.5% are going to be pretty obvious that they're cultivating agriculture. that's going to be pretty straightforward. And I agree, though, that I think that there needs to be some tightening up on what a family farm is in the code, because it is pretty broad.
Okay. I believe this question, Victor, came up when you were on slide 20. I made a note. David LaRue asks, if dad died in 2010, where is his 50% stepped up basis valuation in the tax basis?
So as I read it, for the step up in basis, that's for resale. That doesn't deal with property taxes. So in the scenario that I was talking about, so you would get in California, because it's a community property state, you would get the double step up in basis. So you get the step up in basis in 2010 if mom wanted to sell the property, and then it gets stepped up again in 2021 when she dies. But none of that has any impact on your property taxes. But it would have an impact if mom decided to sell the property, or when mom passes away, if one of the kids or grandkids, they sell the property. But that's what the step up in basis is for.
Okay. Tom, anything on that one?
No.
Okay, next question. How are properties in LLCs affected by Proposition 19/SB 539? So how are properties in an LLC affected?
So I could tell you, I could answer that by saying it depends. Because when you look at a legal entity, they are not people, right? They're their own legal entity. So parent-child exclusions become much more tricky and much, many people, I mean, we've seen people move out of an LLC. Let's say it's husband and wife. They own an LLC, they move it into their trust, right? Then trusts have a lot more flexibility, and then they move it back into their LLC. All I can tell you is it all depends. And I hate not being able to answer a question, but when you get into legal entities, it gets very complicated, very convoluted. That's when you need to either call us first or talk to your attorney about how that would be handled under the property tax code. Just remember, legal entities cannot have children, so that becomes an issue. So it kind of depends on how the whole thing is handled. I'm not saying there's not a way to do it. And Victor might be able to chime in because he's a lawyer and can give opinions more than I can. So.
Sure. So the key thing is, once again, everyone's going to be separate and different depending on what the LLC is for. So is it just you and your spouse? Is it you, your spouse, your children? Is it you, your spouse, your children, and another rancher that's with you? Is it, so you're gonna have all those questions because you're gonna be changing whose property interests are in it. And so I really wish it was a simple answer, but you're gonna have to just talk and figure out what's going on and really work your way through all of the players, because it can have a big impact on who gets it. It's a lot easier if it's just an LLC that's just you and your spouse, and you put that interest in a trust. That's obviously a much easier scenario than it is if it's, I'm a partial owner, your son's a partial owner, your neighbor's a partial owner, and then the majority of it's owned by you. Because that's just going to have a whole different set of consequences and facts on how it gets reassessed.
Similar question. What if the farmland is owned by an irrevocable trust and in a LLC?
I'm going to hand that one off to the lawyer.
Yeah, that's going to be a tricky one. Irrevocable trusts are both a blessing and a curse. The problem is if it's an irrevocable trust, you don't own it anymore. And so I'd have to look at the individual facts behind it and the language in the trust. Because if the irrevocable trust is holding it for your kids, it's going to be different. If it's being held for your grandkids, that's going to be different than if it's being held for you by a third party. Or sorry, if it was created by a third party for your benefit. Yeah, that one, that's too broad and there's too many factors in there for me to, I'm just gonna be guessing if I really try to opine on that. So I apologize. I wish I could do a better answer, but there's just too many factors there.
Similar vein, will putting the family farm into a family trust avoid the residency requirement for the inheriting child?
No, I mean, I don't think it will, because if it is, well, first of all, going back to what Victor was just saying, if it's a revocable trust, right? What do you consider a family trust? But if it's something that is revocable, we look through that and see who the beneficiaries are, right? And but you still, the residency requirements are not waived.
And just
At least as of today.
true. Yeah. And the other question is and Tom brought this up, and I'm not trying to advocate for breaking the law. Please don't. How are they going to know? Right? I mean, are you going to walk in and say, well, I was there for 3 months. My brother's going to be there for the next 6 months. I'm coming back in 2023. I think my sister's going to be there in the interim. So why don't you swing on by our house? I don't know, say this time next year and see if someone's there. There's just a practical question here. So are they gonna, because we didn't go into it, but there's language in here where there's an emergency board that gets created and all this other stuff to help try to implement this. Well, are they gonna give the assessors like quasi police power to implement this, to enforce it?
I hope not.
Well, I know it's not an obligation that you would, what the assessor's office would want, but if are they supposed to call the police if someone doesn't, or the sheriffs? What if you do it for part of the year, but then the next year you're back living there the full time? Like, at what point, and this is where it's just that litigation's gonna just have to pan this out. There's just so many questions up there. But at what point, just going back to the who's on the farm, how do you define that? How do you determine that they are or not on the farm? That's just a difficult question. And if one of you wants to be a guinea pig, don't call me. I don't want to deal with that.
I can add a little bit to that. The association is advocating for we send out a card once a year, and you say, under penalty of perjury, are you still at this residence? You sign it and send it back. That's all I'll say.
All right. I will go back to a question that was submitted ahead of time from Maryland. The bill also clarifies that a quote family home and a quote family farm legal parcel upon which the family home is located are eligible for individual exclusions from property tax reassessment under Prop 19. So does this mean there are two exclusions, one for the family farm and the other for the farm? I don't know if she meant home there. Would this add up to a $1 million for the farm and a $1 million for the house? In my case, since I only have one parcel where the farm and house sit, so would that only be $2 million exclusion or just 1 million? Oh, that's a lot of questions there, sorry.
No, well, bottom line is it's two. So you get one exclusion for the house, assuming the children or the grandchildren, apply for the residency, within a year and homeowner's exemption. And then you get a second one for the parcel, which obviously doesn't require homeowner's exemption or residency because there's no home on the rest of the parcel. So yes, one parcel has a primary residence. If the child moves in, then they get the $1 million, and then the property itself gets $1 million.
Okay.
And I hope that every scenario is that simple.
I'm going to ask, do you have anything on that one, Victor? No.
I would agree with it. I would agree with that analysis on that one.
This was my last pre-submitted question, and I think I can answer this one. What are the requirements for defining a property as agricultural? I own a 240-acre parcel with about 5 acres irrigated in tree fruit, some small box canyons for grazing, and the rest could be grazed. Would this qualify as agricultural? And I would say yes. Based on the definition we've heard, that is a family farm ranch that could qualify. Okay.
Yep.
All right.
And I'll jump in there. Just because of, yes, I agree with you on that, but where there might be some confusion or there might be some litigation, once again, that whole question of legal property versus parcel number, like the distinction there. will they try to parse it down as much as they can to say it only qualifies to the 5 acres plus, I think you said there was some ravines or some land that was used for grazing, like those ones, okay, that might be one parcel that they say, and then they go the rest of it that you're not using as grazing, will that qualify? I don't know. And I wish, once again, I wish I could give you a yes or no answer to it. But I could see that being one other spot where there's litigation for clarification, or hopefully something from like a Senate.
I can tell you, yes, my office would see that as one farm.
Okay.
You got to remember, I mean, some farms have land go fallow. During drought years, you may not be running cattle on a portion of it. That's okay. It just is the long-term use in farming. Could you rent it? We don't value property for whether you're really good management or really lousy management. We value on what a reasonable person would be doing. So just because you're not running cattle on part of it doesn't mean that you can't. And so we would, and I don't think there's any assessors in the state would disagree with that. Look, at the bottom line, we don't have time to take that ranch and to parcel it down and say, okay, this 5 acres we're treating this way, and these areas that you actually run cows on this year this way, and the rest of it we're not gonna. I mean, we just don't have the time, resources, or effort. It's not worth it. We don't have a dog in that fight. If it's reason to assume, we look at what is reasonable by a casual observer. If they think that, and that in this case was Brent, he said, yeah, that's a farm, and I think assessors would agree.
Well, that's good to hear.
Good. We got another question from Bradley Rowan. Bradley asks, do you see any changes to investment properties? I think this is kind of a big picture question. Do you see any changes to investment properties now these properties will be reassessed at time of owner's death?
I mean, I can answer that real quick. What happens if you get a reassessment and your property taxes quadruple? Whoever's in that building, the rent's got to quadruple. So you're going to see prices increase for whatever it is, whether it's retail, whether it's commercial. An investor is not going to eat that. They're going to have to pass it on to whoever the final consumer is. So I think that's what the question goes. But as property taxes increase, so do rents on investment properties. Otherwise, investors are not going to invest and the property values will drop. So you're either going to see property values drop or you're going to see rents go up. I mean, that's what happens when taxes are raised. Whether it's property tax, whether it's income tax, doesn't matter what it is, it gets passed on to the final consumer because an investor is not going to pay for it out of his pocket. The benevolence of his heart or her heart is not going to happen.
I remember we raised these same points on Prop 15, Tom, that we worked hard to educate people about. So that's the same. Yeah, that's what these taxes have repercussions on everyday people. All right, next question. If there are 4 parcels with 1 home on each of the 3 parcels, so we got 4 parcels, 1 home on each of the 3 parcels, and 3 kids living on a separate parcel on the family farm, how would this stuff figure in?
Okay, I'm a visual kind of guy. I got to see that question. 4 parcels, well, home on each of the 3 parcels. So I assume the 4th parcel is just cultivated. 3 kids living on a separate parcel on the family farm.
I think the big problem you'd run into in this scenario is it has to be your primary residence. So the fact that you have 3 homes on this parcel isn't really going to help. What you're end up going to have is you're going to get the credit for the primary home. But then if you have the other parcel, so I think in this scenario, you would end up getting 5 exemptions. So you'd have 1 for the primary residence. Then you would have the rest of the land there in that first parcel. Then you would have 1 for each of the other 3 parcels. I think that's how I would look at it.
If there is farming on those parcels that have the homes, yes. But the home itself would be reassessed. Because remember, we have to carve it out. So you only get 1 home, it's your primary residence. Under the repeal of the death tax, no, you'd be fine. But up to whatever that $2.4 million base is. So you'd be better off. I wouldn't say you'd be fine, but you would only get the 1 for the primary residence. and then the other for the land with separate parcels. So we would have to actually carve the other two houses out, reassess that house, value what the land is, and then apply that only to the land side.
Okay, I don't see any other questions. Now is we're going to say last call on questions. So if you've got a question, please go ahead and type it in the Q&A box if you're able to. We're going to go and give Victor and Tom just last parting thoughts or anything they want to emphasize before we close out here.
No, I just appreciate your time and I appreciate the interest. I just want to reemphasize one thing. Don't do anything with your property crazy or out of the ordinary until you talk to the assessor's office and or your legal team, because property tax law is crazy, it's convoluted, and as Victor said, sometimes it's in conflict with the best thing to do for estate planning on the income tax side. So there's just so many factors that you have to consider. Don't do anything in a knee-jerk reaction.
I would second that. And the big thing here is this is gonna take a long time to iron out. Some of it might be retroactive, some of it might be only going forward. So if you're not in a position right now where you have to worry about if someone's, if no one's ill or dying, or obviously you never know because crazy accidents can happen. But take your time on this. As he just mentioned, don't jump the gun on this. Don't try to get it done right away just to make you feel better or to get it off your chest, because you might end up shooting yourself in the foot in the long run. And then there's so many things that are just going to pan out over the next couple of years as this gets litigated. And right now, it's going to take a while, because right now things are taking, if you want to get something to the appellate level, so people were just started filing suits earlier this year, we probably won't start getting decisions for 4 or 5 more years.
And you got to go through the appeals board first, which takes at least 1.5 years. So yeah, I mean, that is true. And the last thing that I will add to that is that, again, don't rush into anything if you don't need to, especially if Howard Jarvis gets this on, you don't want to do anything now that Howard Jarvis might erase with this initiative unless you have to. So patience on this stuff is always the key, because Victor's right. It's going to be years and years and years before some of this is settled, and gosh only knows what's going to happen with it all.
All right, I'm going to add my parting thoughts. This is a expert panel. We wanted to thank them for their time, but also I think this is a lesson, and Tom would have told me this last October, November, but when we see things on the ballot, we have propositions. Just vote no unless you're really sure that's a good thing. Most of the time they're not, and they may have good sounding stuff, but we want to thank you guys for your time and good information. We want to thank all of our attendees. I posted both your websites, and we have here, amen in the chat box, but we've got a link to Victor's firm where you can find his contact information. We also got the county assessor's website. If for some reason you didn't get either one of those, their contact info will be in their presentation slides. Sometime today or this week, you'll receive a link to the recording of this, as well as a PDF probably or a PowerPoint of the presentation slides you saw today. And with that, I'm going to let these guys.
Wait a minute, hold on. I can't let you have the last word, because when you said something, it popped in my head when our conversation last October. Never, ever just look at the title and summary. You go back and look at the title and summary on Prop 19. It didn't talk about the parent-child thing at all. Even our own realtors associations, after it passed, and we started talking, well, even before it passed, they were not even given the full information. The State Farm Bureau was not given the full information by the proponents. So this was a very much a political wool pulled over people's eyes. So you don't, if you haven't, look, if there is a ballot initiative and it's really important and you don't understand it, you still vote no, it'll come back. So if it is something that really has to be done. So, if you don't understand it, vote no. And don't lean over the fence to your neighbor who read the title and summary and told you how they're going to vote either. Do your own study and your own conclusion, and think independently and think agriculture.
All right, gentlemen. Thank you so much for your time. Thank you, everyone. Have a good rest of the day.
Thank you.